This afternoon, you're listening to the Todd Laborwit Show, Real Estate Radio and Sound Broadcast Network, WRC 1260 AM. I'm your host, Todd Laborwit, and this segment is brought to you by Topaz Mortgage, our preferred partner for mortgage brokering. And in the studio with us now is the house lawyer, Harvey S. Jacobs. Thank you so much for coming back because I need you here.
No problem, Todd. Anytime.
We need some legal advice for real estate, and it's coming across on my applications. People are buying houses. The inventory is up. It's starting to balance itself out in the area, and there's a topic that keeps coming up, and I don't know how to answer. I know the answer, but I don't want to give the answer because it's not my place to give the answer, and that is having the title on the property. For our listeners, what we're discussing is when you buy a piece of property, you have the owners of the property, and it can be held in different ways. And if you let the mortgage loan originator decide for you, it's not the best thing to do. And what I try to educate my clients over at Topaz Mortgage and also our listeners is the more we educate you and give you the choices and the options that you understand, you can select what is in your best interest. So here's Harvey Jacobs, and we want to talk about tenants in entirety, tenants in common. I always put everyone in tenants in entirety, unless the circumstance is different, and then I tell them to please consult with an attorney. And here is our attorney.
Okay. Well, Todd, there are 4 basic ways of holding title, and holding title is a very, very important topic to be addressed. Solos have only one way to hold title, and that's in their sole capacity.
But real quick, Harvey, in the selection process for us, when someone is solo owning it, it says unmarried woman or unmarried man or single man, single woman. And that can confuse some not kind of new loan officers.
Well, the reason that we put marital status is for title searchers going forward to know that if someone is married but they're taking title in their own individual name, to be looking for that same name when the person sells the property. And if they find that the property goes into the sole person's name and it comes out of Mr. and Mrs., that's a problem unless there's a deed that connects the chain of title. For co-owners, there are 3 ways of owning property, and the strongest by far is the tenancy by the entirety, which you referred to. That can only be a tenancy for a married couple, now including same-sex married couples. They have the benefit of having a tenancy by the entirety. And when I say that's the strongest way of holding title, what that means is the creditors of one spouse cannot reach the property unless they have a judgment against both spouses. So that allows the property to be held in a very, very strong manner. If they are not married and they still want to have the benefit of survivorship, one of the things that the tenancy by the entirety gives the couple is the survivor of the two. If one of the spouses passes away, the other spouse, by operation of law, becomes the owner of 100% of the property, and so they don't have to record a deed or anything like that. What we suggest is they simply record the death certificate so that the land records can show what happened to the other spouse.
So when you have in tenants in entirety, which you said it's a married couple, and what happens if it's like a mother and a daughter?
If it's a mother and a daughter, you cannot have a tenancy by the entirety. You can either then have a joint tenancy with right of survivorship, referred to as a JTWROS, and that will give the mother-daughter team, if the mother passes, then the daughter, by operation of law, becomes the owner of 100% of it. It also allows the parties to make sure that they don't have different creditors attaching more than the 50% that the mother or the daughter own. The other type of tenancy is a tenancy in common, which is more in the nature of a business transaction, where if 2 people were to buy a piece of property as an investment, or an unmarried couple that didn't want to leave the other one with 100%, you would use a tenancy in common. And that can be 50-50, that can be 70-30, it can be all manner of percentages. The risk with a tenancy in common is that the creditors of each owner can attach the property, and that can go a long way to screwing up the title. if they'll go to refinance or sell the property.
It's interesting because a lot of things default to tenants in common, and people don't realize the position that they're in.
Yeah, critically important is a married couple contemplating divorce. When a married couple that holds the property as tenants by the entirety get divorced, at the moment of divorce, they become tenants in common. And if there are judgments against, say, the husband for speeding tickets or a credit card judgment or anything, that judgment attaches immediately to the husband's portion of the property, and it encumbers the property.
Wow. Well, by the way, if you're just tuning in, I have with me Harvey S. Jacobs, attorney at law or real estate house lawyer for the show. I'm your host, Todd Laborwit, and you are listening to Salem Broadcast Network, WRC 1260 AM. Now, Harvey, I'm learning more just now. I thought I knew everything. Wow. I even have a case right now where somebody wants to come in and they want to buy it with their son, and they want to own 99% as the parents, and the son will own 1%, and I'm doing the loan as a non-occupant co-borrower, and the investor is saying, look, we're just doing it as a non-occupant co-borrower. I don't know what happens. I don't even understand it.
Well, that would be a...
I know what I'm doing, but
Yeah, that would be essentially that would be a tenancy in common. I often get calls from folks saying, I'd like to add a loved one to my deed. I'd like to add my wife, my spouse, my son, my daughter, my son-in-law, my second wife, my girlfriend, what have you. And it sounds very simple. I think people think that all we do is we go and we pull their deed and we pull out a Bic pen and we write their daughter's name or their son-in-law's name. But there are significant implications. Usually my response to them is you really need to go through the steps. I ask them how much equity they have in the property. If it's a $500,000 house and they have a $200,000 mortgage, they'll have $300,000 worth of equity. And when I put it to them that way and say, so you want to add your daughter to your deed, are you prepared to give your daughter $150,000 in cash right now?
Wow.
And that usually sobers them up, and they think about it, and they may want to, but they want to think about it. And then I say, well, what if your daughter has a judgment against her? What if she has a fender bender and gets a judgment against her for $50,000? Well, that daughter's judgment will attach to the mom's house. And so they have to think these things through. If the daughter gets married and perhaps they don't like their son-in-law, and the son-in-law and then the daughter gets divorced, and somehow the son-in-law gets challenges the title, that could implicate mom's property as well.
I always knew you were a wealth of information, but wow, you're just blowing my mind right now because...
Don't want to be a wet blanket, but as long as you understand all the implications for joint tenants, tenants by the entirety, and tenancy in common, you can make the right decision.
But out of all the clients that I have had through refinances, through the purchase clients, when they're coming in and talking to me, and I'm doing the application, and I'm like, oh, you should talk to your financial advisor, you should talk to this person about how it should be done. If you do have an advisor in place, they can most likely probably answer it for you. And if you can go to you, it's actually you'd be a really good advisor for a lot of my clients, Harvey, is what I'm trying to say.
Well, you can't go wrong typically by advising a married couple to hold title as tenants by the entirety. That if there's a takeaway from this discussion,
I understand that, but people are getting very creative. I got parents helping their children buy houses. I have children trying to help their parents with whether they should do a reverse mortgage or they should do this. I have people that want to do a 203K. There's so many different products that are out there that it's very important to consult with an attorney or someone that can lead them in the right direction, because when it hits the fan hard.
Well, have them call the house lawyer. I'm happy to speak to these folks about that. And it does take a little bit of analysis, and you do need to contact somebody who knows what they're doing. And I'm happy to offer a free 30-minute phone consultation for any of your listeners that want to that are contemplating buying property or retitling property. I'm happy to give them that advice so they don't make the mistakes. A free 30-minute consult would be more than happy.
Is that with you talking or them talking or being on hold?
I'd say 30 minutes total. If they take 29 minutes to ask the question, I'll give them a 1-minute answer.
No, I'm just teasing you. But yeah, so what I'd like to offer you, our listeners, is an opportunity to get in touch with Harvey Jacobs, the House lawyer. He also writes for the Washington Post. You can call or text me at 301-467-8444. That number again is 301-467-8444. And having that 30-minute free consultation, boy, let me tell you, you're going to get a lot of information, and it's going to be all tailored towards you, because if anybody I wanted in my corner, if I had a real estate legal question, you are one of them, along with some others, but you're also a very wealth of knowledge. And where did you get all this? Is this from writing for the Washington Post?
Well, I've been doing this for 31 years. I've been practicing law 31 years in New York, Maryland, and D.C., and I enjoy reading case law.
Perfect. Well, Harvey, thank you so much.